Good to be with everyone on today's program. We're glad you're here. Have I think, very informative program and tremendous group of panelists here today. I'm going to hear from three of my colleagues. First, Gabe Oberfield. Gabe's going to talk about how things are going with respect to telehealth and some post-pandemic considerations in that area and with data privacy. Laura Harshbarger is going to talk about some potentially significant new laws and legal developments for employers to consider. And I know that will be of interest to everyone. And finally, Sandra Casey from our Albany office will be discussing some also very significant developments in the area of higher education. Before I turn it over to our panel, I just want to go through my usual COVID update for everybody. We're continuing to see positive trends, getting to the point where things are continuing to resume back to normal. So you'll see on the next slide some of the same trends that we've talked about. Kathy, can you advance the slide? Thanks. So again, we see that very precipitous decline. Just for reference, again, this is all US right here. At our peak in early January, we were seeing over 1 million cases. That has now declined as of March 7th, Monday, to just 67,000 cases currently. On the next slide, you'll see some data in New York. Again, continuing that positive trend. And I would say, if you look closely at the number of cases, we're even dipping below where things stood before the dramatic rise with the Omicron variant. They're seeing just an average of 25 deaths per day, significantly down. And of course, the number of cases on the 7-day average is also significantly down. We're at just about 1,800 as a 7-day average come March 6th. Compare that with the peak that we were dealing with not long ago of 85,000. So continued positive trends there. Now, every time I start to relax a little bit, I think hopefully we're finally over this and moving forward. I try to look at what are some of those other leading indicators that we've seen in other regions, and two come to mind. One, Israel, and the second is the UK. So I decided to take a look at the data in those areas just to see what their trends look like. On the next slide, you'll see Israel and timeline comparison with some of the same data there. So you see that again, the spike that we saw here, the pattern is not exactly the same as one would expect to the United States and New York, but there are similarities. I did note that both the number of cases, 7-day average, as well as the number of deaths continues to be low. Frankly, is even lower than here in New York and in the US. So we're again not seeing a different trend, right? That may be a leading indicator there. And next slide, you'll see in the UK, likewise, we're seeing that same trend, not a significant spike. Their numbers are higher than what you're seeing in Israel in terms of just the gross and the average numbers, but again, same positive developments there and no marked contrast. I'll keep my eye on those for sure. I did just want to mention a couple related COVID points. I took a look at the questions that were submitted at the end of last week's program. A number of you had questions about New York's HERO Act. You'll see on the next slide, the designation, the emergency designation is still in effect. It's set to be in effect until the 17th of this month. I can't speculate firmly one way or the other whether we'll see that renewed. I do note, as we'll talk about in a little bit, that the metrics that the state had used previously were based on the transmission rates that the CDC established. And they were looking at those rates and deciding whether or not to extend the designation. As we'll talk about in just a minute, the CDC has changed those metrics, the green, yellow, and red. And perhaps we'll see, and we've seen positive developments here in New York with those changing standards. And again, perhaps that will motivate the state not to extend the HERO Act. But for now, you must continue to follow your plans as been modified with conformity to new state guidance. Again, screening, that's a common question I get. I think it's something you're going to want to work with your legal counsel if you have questions, specific questions about whether screening is required in a particular circumstance, but that is something that the model plan that the state put out under the HERO Act does contemplate, and it's something that I believe employers are continuing to undertake currently with the emergency designation still in effect. With respect to masking, as you know, we saw a number of significant developments, and the state lifting and rescinding its general order and requirements for indoor masking. There are still requirements that remain in place, last I checked, when it comes to hospitals, skilled nursing, and certain other facilities. And of course, last week we saw the state adjust its masking guidance for schools. Positive development there, of course. And again, an indicator that we are moving past, hopefully on a more permanent basis, the pandemic and the most recent Omicron variant. Another question that we saw dealt with COVID paid sick leave. Of course, we still are seeing positive cases. There are still isolation and quarantine requirements that will apply in those circumstances. And the COVID paid sick leave benefit, to the extent it covers your operations, does remain in effect. There's no sunset period for that particular benefit. It doesn't expire. It remains on the books. And if you have an employee who tests positive and is subject to a governmental quarantine or isolation order, otherwise, remember that benefit could apply, and you're going to want to work with your favorite bond attorney or other legal counsel to address any compliance issues on that front. Okay, so that's the update on all things COVID. Oh, yeah, thanks, Kathy. Just before I move on to Gabe, this is just a slide, and I'll send you a link in the chat that deals with this CDC's changing assessment and the metrics that they're looking at. And it's relevant to whether or not they're recommending masking. Again, New York has taken its own position when it comes to masking, and the State Department of Health has issued its own advisements on maskings, which should inform employers here in New York as to what they should or should not do in a particular circumstance. But again, employers are still free, right, to impose certain masking requirements if they see fit or if they decide that that's appropriate. And in that regard, the guidance from the CDC can be informative on this. So what I have included here on this slide is just a snippet from the CDC's website. And again, from that transmission rates that were used as a metric before, they pivoted now to this community level, and a number of factors are being evaluated here. It'd take too long to go into all of them. But what we see is on the image to the right is how things stood at least as of March 3rd. And we see a very, very positive development there where our state is entirely encompassed with either low or medium community levels. So again, a positive development there, certainly triggered by the adjustment of the factors, but wanted to share that information with you. Okay, so without further ado, it's my pleasure to introduce my colleague, Gabe Overfield. Gabe works in our downstate office and is here to present to you today on some of the telehealth issues, as you know, that grew in prominence and practice for many during the pandemic. What are we likely to see post-pandemic, and what are some of the data security issues that folks should keep in mind? So, Gabe, thanks for being with us today.
Oh, my pleasure, and thank you for having me, Andy. And looking forward to sharing some thoughts on this important issue. Kathy, would you mind advancing to the next slide, please? So what we're seeing, as Andy was signaling in his opening remarks, is a paradigm shift. Knock on wood, we're coming through the worst of this pandemic, and we're starting to move into a place where we can think about, well, what really will come next for all of us? And that optimism is something that I feel here in New York City, where I'm speaking with you from, where masks are coming off, and there's definitely a sense that it might stick this time. And so as we begin to contemplate what our new normal looks like, it strikes me as worthwhile to talk a bit about telehealth, because as Andy has noted, it's become a huge part of the way healthcare has been delivered over the course of this pandemic. Its growth has been really exponential. And let's talk about where it is now and where it might be going. Next slide, please, Kathy. So some of the ways that telehealth has really burst onto the scene include with behavioral health. The reach of behavioral health has just been entirely transformed by telehealth, and there is a sense that a lot of that will stay. Access to underserved communities has changed dramatically by way of telehealth. Not a solved matter for sure, but certainly in rural and in urban communities, it has, as a tool, important dimensions that affect health equity. Certainly more to that story that we'll be watching in 22. With emergency preparedness and response, telehealth really just extended in really profound ways the reach of our healthcare delivery system at a time where, particularly during the worst of the first surges, hospitals and health systems were overtaxed and could not really reach all those who needed healthcare at a time when it was so critical. Just one measure of the ways in which we've seen telehealth balloon. If you look at data from the Health Resources and Services Administration, a federal agency, among entities that it funds, when you look at 2019 versus 20, there was a 6,000% increase in telehealth usage, which is obviously a dramatic number that we're unlikely to see in terms of growth anytime soon. There are continuing market developments that are also really important to be aware of. Some of the big names, the biggest perhaps of all, Amazon has announced a partnership with Teladoc Health, where through Alexa and Amazon Echoes at home, there is going to be effort to connect individuals to physicians first by voice and then ultimately by video. So there's more to come here from the private sector, certainly too. Next slide, please. So throughout all of this growth in telehealth as a means of bringing care delivery to new locales and otherwise through the seamlessness that technology can afford. What we're also, of course, thinking about is there are all different types of data privacy considerations that layer into this, whether you're talking about your iPhone or the new app that is involved in connecting healthcare providers to care delivery recipients. Many implications from a regulatory perspective that are just beginning to unfurl. Congress is looking at a number of these, certainly when it comes to HIPAA, for instance, which of course has a really major role in the regulation of healthcare delivery. And during 22, I expect we'll see more focus on, to the degree telehealth has been so transformative, how can we integrate it in a ongoing way once some of the public health emergency regulatory relaxations abate into a more permanent position. So next slide, please. So as employers here joining this webinar, there are a couple of different ways to think about these questions. First, are we going to be seeing government as a trendsetter when it comes to telehealth and our continuing connection with it as a tool, whether it's the Medicare program or the Medicaid program? As I noted, we saw a major amount of change in both of those programs, but really driven by regulatory relaxation that came with the public health emergency and other kinds of changes in the ways that essentially nationally and at the state level, we tolerated healthcare delivery and the overlays of data privacy. Some of that will certainly stay, and we're seeing indications of that. Some of it may, though, ultimately be wound back, and that's going to be really fertile ground for state and federal discussion over the coming weeks and months. Commercial insurers sometimes take their signals from government, and sometimes they don't. We saw in 20 a massive shift to telehealth provision, and what we are still trying to determine is the degree to which that will be what we see in 22 and beyond. I think there are a lot of different advantages for insurers in terms of the cost of care and the ways in which telehealth can really bring that down while keeping quality up. But these are open discussions. There are also labor and employment implications that certainly overlay Think about collective bargaining, for instance. Is telehealth going to be part of bargain for health benefits on a going forward basis, on a more tested basis, given that we've seen just how useful telehealth can be? More to come with that story. Direct to employer benefits are also another place where telehealth may be really something that takes further root. We saw some of that getting underway before the pandemic with concierge style health plans that brought care directly to consumers. And what really comes of that is an open set of questions that we'll be tracking for all of you. All of this, of course, comes in an environment where healthcare delivery is changing every day by way of the technology that continues to unfurl. Telehealth is just one part of that story, and there are many more pieces to that continuum that will all be contributing in our post-pandemic environment. And we look forward to bringing you further updates on what that looks like. So Kathy, if you'd go to the next slide, please, I'd appreciate it. And so we're looking at these issues of telehealth in the integrated approach that really it requires. It's not just a healthcare question. It's not a data privacy and a cybersecurity question. It's not a labor and employment question. It's really all these things and more. And so these are the types of integrated approaches that you know your bond attorneys for, and that will bring to issues like this. If you're interested in reading up a bit more, I published an article earlier this month on these matters, which you can find on the bond website. And of course, please feel free to reach out to me. I'd be delighted to discuss anything that I covered in this presentation with you. And with that, Andy, thank you very much. And I'm looking forward to hearing what my colleagues have to say in the forthcoming presentations.
Gabe, thank you. Great to have you with us. Another one of these areas that we saw proliferate incredibly, and brought a lot of benefit with it for many people. And it definitely is going to be interesting to see how, as we pivot here, these matters are addressed, and certainly relevant for all of our employer clients on this webinar. So thank you again for joining us. Appreciate it.
My pleasure. Thank you.
All right, so next it's my pleasure to welcome my colleague Laura Harshbarger. Laura is going to talk to folks today about some very notable potential developments that we are seeing percolate through the legislative process in Albany. So stay tuned here for sure, folks. I think this is going to be very interesting. Laura, thanks.
Good afternoon, everyone. So for those of us who follow this area, and all of you on this call do, relative to sexual harassment, discrimination, other forms of harassment and retaliation under our New York State human rights law, you will recall that over the past several years, there have been significant developments in this area. We can think back to 2020, where there were very significant amendments to the New York State human rights law. We geared up for annual training, right? Annual sexual harassment training. And that's been within the law for the past several years. We also saw changes being made in New York State law that limited at least one kind of provision that could be in a settlement agreement if an individual brought forward a claim of sexual harassment, and that related to confidentiality. So if any of you have been involved in settling a sexual harassment claim recently, then you will know that one of the issues that gets discussed is the extent to which we can have a provision in a settlement agreement whereby the plaintiff or the complainant states that they are willing to not talk about the underlying circumstances of the harassment. And generally speaking, the new law which is already on the books, requires that there be certain disclosures around that to the plaintiff and in the agreement, and that there be basically a 21-day waiting period associated with that. So that's all the kind of historical developments in this area. What we're seeing now is more of the same, and in many ways, some more consequential movement in that direction. This seems to be following the Governor Cuomo's sexual harassment scandals. And you can see that the state legislature is attempting to make some changes to respond to the allegations that came up in that case. And these will have consequence for all of us who are in public and private employment in New York. So I'm going to start with two developments that have already passed. They passed both the Senate and the Assembly, and they're waiting for the governor's signature. These don't affect us so much in the private sector. So the first is a clarification that the New York State human rights law and all of its protections against discrimination and harassment and retaliation apply to all public employees, including personal staff of judges and elected officials. And you wouldn't think that that was so significant, and in many ways, again, it certainly isn't for most of us. That had been an issue of lack of clarity in the law, and this is just making sure that there's no ambiguity about the scope of the human rights law's protection to public employees. So that one is just awaiting the governor's signature. There also is awaiting the governor's signature an amendment to the New York State human rights law and its provisions around retaliation. And this would state that it is retaliatory to release an employee's personnel records in an attempt to kind of get back at the employee for making protected complaints about harassment, discrimination, and other unlawful, that similar kinds of conduct in the workplace. Again, this seems to have very clear resonance to some of the allegations of the ways in which the governor responded, that Governor Cuomo responded to the allegations against him. And the idea is to protect accusers from having their integrity questioned or undermined. And so this protects their personnel records. I don't think it is a lot of application or kind of a big ground shift for most of us in most of the allegations and situations that we encounter. Again, that is awaiting the governor's signature. So now we're going to move on to some developments that have not yet made their way fully through both houses, the Senate and the Assembly, but very, very likely may. The first would establish a hotline for sexual harassment, and this law would require the New York State Division of Human Rights to set up a confidential hotline to man it 9 to 5, Monday through Friday, with individuals, including pro bono attorneys, who are willing to counsel individuals who call the hotline with concerns about sexual harassment in their workplaces, and to provide some advice on how to respond for those individuals. That at this point has passed the Senate. It has not yet passed the Assembly. What that would do, I think, for those of us in the labor and employment world, would certainly provide some additional resources to individuals with these concerns. We might see an increased number of complaints. I don't know that one will be terribly consequential for us. However, there is also a law that has passed the Senate, has not yet passed the Assembly, that would extend the statute of limitations for claims to be brought under the New York State human rights law. Currently, if an individual wants to file a claim with the State Division of Human Rights, they have 1 year to do it. This law, if passed and signed by the governor, would extend that to 3 years. So a person would have 3 years to file a complaint with the New York State Division of Human Rights. The law also would extend a person's time period to file in court. So right now, if a person prefers to file in court a claim that is alleging a violation of the New York State human rights law, so any form of discrimination, harassment, retaliation, they have 3 years in which to do it. But this law would extend that to 6 years. So that would be a much more expanded statute of limitations. And again, the impact for employers would be a longer period of time in which there is exposure to those kinds of claims. We'd have to think about increased record keeping to make sure that we're prepared to respond to such a claim. The next law that has passed the Senate is being deliberated in the Assembly, and we'll see if it passes the Assembly, is a law that would ban a different kind of provision in settlement agreements. And this is called a no rehire provision. So it's a very, very common, not in every settlement agreement, but it's a very common provision to place in a settlement agreement. And it says basically that as a result of this settlement, both parties agree that the plaintiff isn't going to work for the employer anymore and won't have a claim against the employer if that employee is not hired in the future. The reason for a no hire provision in a settlement agreement is to ensure that we are not on some Ferris wheel of round and round of claims of retaliation and discrimination from this same person. The idea being if we're settling, we understand that going forward, you can't kind of collect the settlement and then the next day apply for another position and then have a claim for retaliation or discrimination for not having been hired for that position. So again, it's a very common provision that you would find in a settlement agreement. This law that has passed the Senate at this point is awaiting its fate in the Assembly, would ban those kinds of provisions and would say if a settlement agreement has that kind of a provision, that the waiver and release of claims, which is of course what protects the employer from future allegations and claims and lawsuits, that provision is not enforceable. So this would be a very, very significant development. It would change in many ways some employers' calculus about whether or not it would make sense to enter into a settlement agreement at all if there is no assurance of kind of future peace and no assurance of protection from future retaliation claims based on a failure to hire that same person in the future. And the last law that we really have our eye on here, and we're tracking its progress, is called the Let Survivors Speak Act. This has passed the Senate. It is also awaiting its turn to be voted on in the Assembly. This piece of legislation would provide that an agreement is again not in that the waiver and release of claims is not enforceable if the agreement contains a provision that prevents the employee or the plaintiff from talking about their experiences of discrimination, harassment, or retaliation, even if the plaintiff had agreed to a non-disclosure agreement previously. And if the settlement agreement imposes any kind of financial consequence to a plaintiff who changes their mind and now wishes to speak about their experience, the waiver and release provision would again not be valid and would not be enforceable. It's very common currently that if the parties agree that there will be a non-disparagement clause or a non-disclosure clause, that a part of that provision states that if the plaintiff violates that provision, they may have to give part or all of the settlement proceeds back to the employer. Something that's often kind of called liquidated damages that would be paid to the employer as a consequence for the breach. And those provisions would no longer be allowed, or we would be compromising the validity of our waiver and release, which is of course the entire benefit that an employer receives from entering into a settlement agreement. So these are very significant potential developments that we are keeping our eye on, and we will report back as these laws make more progress.
Laura, thank you for the very helpful overview. Yeah, it seems no shortage of action in Albany when it comes to the workplace. And I know our clients and friends of the firm who attendees are very appreciative for these kind of updates. That helps to keep them in the loop. Two things just kind of jumped out at me from your presentation with respect to the lengthening of statute of limitations to 3 years and beyond that. Wow, seems to really put a premium on documentation, to say the least. if we're going to be defending a claim, 6 years, 5 years after the fact. People move on. Certainly people forget things. And I'm just thinking of our HR folks out there. It's gonna really be important for them to train their supervisors and to make sure that they are going through that documentation. And then, I know we've talked about this before too. If you're a business organization out there listening to this presentation and you have what I'll call as a stock separation agreement, and you haven't had that looked at by an attorney in recent time, you should. In addition to the types of potential changes that Laura talked about, there have been a number of other changes that have been enacted that would impact the release of claims under New York law. So you're going to want to have an attorney take a look at that. And in general, given that we see this being a very dynamic area right now, before you use that agreement you've got on the shelf, give some thought to any potential changes there may have been under the law and getting appropriate counsel. So Laura, thanks. If there's any developments on that, we'd love to have you back.
Thanks.
All righty. Next up, we have one of my colleagues in our Albany office, Sandra Casey. Sandra works in the area of higher education. I know we have a number of our higher education clients and friends of the firm on the webinar today who are going to be interested in this update. I am too, as a parent with one in college and another one on the way, Sandra. Looking forward to hear your update. So thanks for joining us.
Thank you, Andy. Thank you, everyone. And happy International Women's Day, all. It's a great day, and I'm wearing my purple in camaraderie with everyone. So if I can have you go to the next slide. The New York State executive budget for fiscal year 2023 contains some interesting proposed pieces of legislation. This is a very high level overview of those main provisions. It's certainly not meant to be exhaustive, but I just wanted to alert you to some of those that I thought were particularly significant. These provisions are subject to negotiation during the budget process and may make their way into the budget that is ultimately passed and signed into law. I will report back to you after the budget has passed and let you know what provisions, if any, survived the negotiation process and what their final language looks like. Next slide, please. The first big one is Tuition Assistance Program, TAP. Currently, there is limited availability for a TAP for part-time students. TAP is available to part-time students who have earned at least 12 credits in 2 consecutive semesters, are enrolled in at least 6 credits in an approved undergraduate program, and have a GPA of at least a 2.0. The Article 7 legislation eliminates the requirement that the student has had to have earned 12 credits in 2 consecutive semesters and only requires a student to be enrolled in at least 6 credits in an approved undergraduate degree program and have a GPA of at least 2.0. Next slide, please. Currently, the award for the TAP is calculated by an enrollment factor, which is a percentage of the credits enrolled in compared to the overall credits required for full-time study. The proposed legislation changes the enrollment factor to one that is to be established by HESC, the Higher Ed Services Corporation. The Article 7 legislation also expands TAP to those enrolled in an approved non-degree workforce credential program at a community college, which is approved by the Empire State Development Corporation and the Regional Economic Development Councils based on an analysis of regional industry trends, workforce needs, and existing program offerings. Next slide, please. Under the appropriation sections of the governor's budget, there is $150 million to cover the cost of expanding TAP to part-time students studying at least 6 credits in an undergraduate degree program. And the executive summary to the budget estimates that 75,000 additional New Yorkers will benefit from this expansion. Finally, TAP for incarcerated students is restored in the Article 7 legislation. There is allowance for federal money for incarcerated students. There's a pilot program, run through the U.S. Department of Education. And this particular state law, if passed, will, offer TAP again to incarcerated students. So this is kind of something, that the law was amended back in the early 90s to eliminate a lot of financial aid for incarcerated students. And now we're seeing that money is coming back to them. Next slide, please. There is also a streamlined program review in the Article 7 legislation by the State Education Department. Any new curricular or program of study that does not lead to professional licensure or does not require a master plan amendment or a charter amendment under the New York State Education Law will be authorized to temporarily operate pending program approval by SED 45 days after the college or university receives certification by the department that its application for program approval is complete. The provision is only applicable to colleges and universities operating in the state for the previous 10 years, is accredited by middle states, and is under the jurisdiction of the same governing body within that preceding 10-year period. Next slide, please. The college or university will be required to disclose to its students the temporary nature of its authorization to operate the program. And if SED eventually disapproves the program, the college or university must immediately cease operation and refund all monies paid by students to attend such programs. So you can see that this would be it would be very risky for a college or university to operate a program under these conditions. Next slide, please. And speaking of the Department of Education, right now, it has oversight of all the medical professions with regard to program, review and approval, and authorizing licensing and professional misconduct. All those functions that the Department of Education currently has would be transferred to the Department of Health effective January 1st, 2023 under this proposed Article 7 bill. Next slide, please. Colleges as polling places, where there are 300 or more individuals registered to vote on contiguous college property, there must be a polling place on such property or at a nearby location recommended by the college. Next slide, please. So this one, we're seeing a lot of movement, prohibition of transcript withholding. It would be unlawful for an institution of higher education to withhold a transcript of a student who owes a debt or otherwise use transcript issuance as a tool for debt collection. The New York State Department of Financial Services would enforce this provision and could issue a penalty upon a school of $500 per violation after notice and hearing. In addition, HESC could suspend, limit, or terminate a school's participation in state financial assistance programs, such as TAP, for a violation. Next slide, please. So there's also proposed legislation pending in the state legislature now that's very similar, and therefore, we most likely will see some form of prohibition on transcript withholding for debt collection purposes by the end of the legislative session. Next slide, please. There's also an amendment to the human rights law. The Article 7 legislation amends the human rights law to add citizenship and immigration status as protected categories in order to prohibit any type of discrimination against a person based upon these categories. The law specifically states that verifying citizenship or immigration status where required by law, for example, that which is required under federal immigration laws or labor rules, would not be considered an adverse discriminatory action. Next slide, please. Currently, federal law prohibits discrimination in employment based upon immigration status, but specifically provides that it is not an unfair immigration-related employment practice for a person or entity to hire, recruit, or refer an individual who is a citizen or a national of the US over an individual who is an alien if the two individuals are equally qualified. There is no such carve out in the proposed amendments to the New York State Human Rights Law under Article 7. Next slide, please. So there are other changes to the human rights law relating to victims of domestic violence to protect them not only from discrimination in employment, but also to all areas under the jurisdiction of the human rights law, such as housing, public assistance, education, and credit. There are also limitations on non-compete agreements and prohibitions of no poach agreements. These and other labor-related provisions in Article 7 were discussed in our February 8th, 2022 briefing by attorney Stephanie Fedorka. Stephanie provided a comprehensive overview, and her presentation can be found here in this link. So I really just wanted to, again, alert you to these provisions. A lot of legislation gets put into Article 7, and it's good for everyone to be cognizant of that because, we can see some significant changes and as part of the budget process. So the budget is not all about just numbers. It's actually, it includes a lot of authorizing legislation as well. So I just wanted people to be aware. And again, I will report back to you to see if any of these provisions made it through their way to the final law. So thank you, Andy, and thank you, everyone.
Sandra, yes, we really appreciate you being here and keeping tabs on these things. Again, there's so much for our clients to keep track of when it comes to these developments. So it's a tremendous resource that we have in you keeping tabs on this in the budget process. And thank you for recognizing International Women's Day too. I have my purple tie on here. This year's campaign is Break the Bias, if I recall correctly. And I think it's important for us to take time to recognize that, and of course recognize that we would all be in a better place in a gender equal world, and we all need to do our part to get there as well. So thanks for mentioning that. Everyone, you see our contact information on your screen in front of you. If you have any questions, reach out to your favorite bond attorney or the attorney listed here for the substantive area. In the meantime, be safe and be well. We'll see you next week.